Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Hey everybody, welcome to an all-new episode of FDA Imports, cross-border compliance with attorney Benjamin England. I'm your host, Mike Leon. Ben's the founder of FDA Imports. You can visit him over at FDAImports.com. And he's a former FDA regulatory counsel turned private advisor to importers, manufacturers, and brand owners who need to get their products through FDA and USDA customs. Today's episode, we're going to be zooming in on country of origin declarations, a detail that many importers think is just a formality, but it's one that can trigger major penalties, detentions, or even fraud investigations. So, Ben, we were talking about this a little off air. Let's start at the high level with all of this. What exactly is a country of origin declaration, and why does it matter to CBP, aka Custom Border Patrol?
Hey, Mike, thanks so much for having me. I appreciate it. It's a good question. It's an important question, particularly now because of the fact that most duty evaluations, tariff evaluations, come down to the country of origin of the goods. So when you see all this news about the fact that Trump has just increased the tariff from the EU for certain goods, or he's threatening the EU to add more tariffs to European vehicles if they don't figure out some way to allow drug companies to increase the price to the European market. What you're seeing is if that gets implemented, then the question then becomes, what's the origin of the car? What's the country of origin of the car? This would be true for anything else. When something comes into the country, it has a country of origin. Country of origin declarations and determinations are creatures of customs law, not U.S. customs law per se. There's actually a lot of agreements across either free trade agreements or in the WTO that are adopted definitions for country of origin. The country of origin is where was the thing made, or where was it grown, or where was it harvested, or where was it fabricated? Sometimes you take in terms of software, like where was it coded, right? I mean, so it's trying to determine the primary location of the origin of the essential character of the good, and that's important. Lots of things like a car have hundreds of thousands of parts, maybe not millions. They have many, 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 many parts, right? Well, so what's the origin if those parts come from 50 different countries? And so there's customs rules for determining sort of what percentage of the thing has to be from a country in order for that country to become the origin. The other thing is, when does the thing become the essential character, right? It might be that my tires are coming from Japan and a bunch of other stuff, but when those Japanese parts come in, when they come in and they're added to the car, they're not making it more of a car. It was already a car. And consequently, then those parts are not affecting origin. The other thing can be value. The other thing can be things like you can minimize the impact of origin depending upon whether you, as a U.S. business, are adding input into the thing, right? I'm supplying equipment. I'm supplying materials. I'm supplying design. All you're doing is assembling it. You're not really doing anything. Well, that starts to question, okay, well, where is this thing from? So origin questions are, first of all, they're very complex. Secondly, they're important because they're important in terms of what tariffs are going to apply, because the tariffs are based upon what the thing is and where it's from, the origin. Not where it was shipped from, its origin. And customs rules in the United States are governed by Customs and Border Protection, and they're evaluated by the Court of International Trade, right? They're not something for FDA or for USDA or even for URI. We could litigate over it with customs, but it's a customs rule. And then the goods have to be marked with origin. So that's why you can see product of Germany, product of Italy, product of India on products, because that's a country of origin statement that's required.
Ben, maybe you can dispel this misconception, because whenever a new administration comes in, there's policy changes, right? So was country of origin important to CBP before all of this tariff activity in these last 7 months?
Oh yeah, this is not new, and which is the good thing. Anybody who's been in the international trade, international businesses, would already understand what origin is and why it's important. But it's not new. And a really good example is look at the free trade agreements the United States has been in for decades. What was once NAFTA, North American Free Trade Agreement, is now the USMCA. Well, what's the question? Is it of Mexican or Canadian or U.S. origin? If it is, then it gets treatment under the USDA, which is going to be preferential treatment with respect to what matters: money, duty. Other things like that FDA might care about, they don't care about origin. They care about where the activity that has the most impact on the goods in terms of FDA is concerned, right? They care about what's in the product. They care about how it was manufactured. They don't really care where it was manufactured unless they care about that facility, right? They may care about it. But with customs, it's not a new discussion. It's a much more important discussion because customs is being much more rigorous in their evaluation of origin. So even though before they would do that, you would get what's called a Customs Form 28 requesting information about the origin of the goods that you declared as origin of Israel, origin of Italy. They'll ask you questions. Now, if you get it wrong, then you're sure to first of all, you're going to pay the duty if there's a duty impact, right? If you ended up getting duty treatment that's lower that you shouldn't have because the origin declaration was wrong, you're going to pay the duty. You're going to pay it plus interest, and you could pay it plus penalties. Whereas before, we definitely paid the duty. You could negotiate the interest. You might be able to walk away without penalties, but you're seeing a lot more of that enforcement.
Let me piggyback on that because you just mentioned something with the FDA. So what's the difference between the USDA and the FDA's interest in the product origin and then customs enforcement of it? Can you expand a little bit more on those differences?
Yeah, sure. So FDA regulates, about it's like 42% of the GDP now because now they regulate tobacco. It used to be like 37%. Now they regulate tobacco. So it's everything you can find in the grocery store, almost everything you can find in a CVS or a Walgreens or the pharmacy, a hospital, right? It's a tremendous swath of economy. USDA regulates food, but it's agricultural food. So it's going to be plants, those kinds of plants and vegetables and seeds, and also then meat, poultry, and eggs. So that's the issue. FDA cares less about origin. As I said, they care about who made it, where it was made, and how it was made. Not because of the origin, because they want to make sure that the facility is appropriate for the manufacturing of the goods to make sure that they're wholesome or approved. Right? Some places you have to make it only in one place, or else your approval doesn't apply, because your approval applies to that particular place. USDA is very origin-driven. In USDA, the vector or the food is the risk is the food will act as a vector to bring in a virus or some kind of a damaging threat pest that can injure U.S. agriculture. And those pests and those viruses tend to be regional in nature, right? So it matters where the food is coming from, because that then applies how the risk is applied, not who made it, or even of course it matters how you treated it to try to control that. But for USDA, it's much more important to know the origin and get it right. So now you don't just only have a customs question, you have a USDA writ with respect to origin. Because if you misdeclare the origin, and that origin happens to have, say, no permit requirement for imported beef, and it actually came from a place that's mad cow risk, right? Now you've got bovine material coming in that's enriched for mad cow, but didn't get inspected or excluded, which it should have, because it was declared as the wrong port of origin, country board.
Are there legitimate ways to change the country of origin, or why would someone want to change the country of origin?
Well, most of it's duty, but also it can be issues like I described with USDA, and not so much with the Food and Drug Administration. Some with DEA, because DEA actually has concerns about certain regions in terms of origin because of the risks associated with articles that might come from those countries. Interestingly enough, you think about some of the IEEPA tariffs that Trump has put on Canada and Mexico and China has to do with fentanyl, right? Well, think about it. That's a controlled substance that there's been a significant negative impact in this country. So the DEA cares about origin as well. It's just a lot less, and not so much. Changing origin is essentially, as I indicated, changing where and when the good becomes the good. Right. So all the things I described before that could impact origin, you can control many of those things. Right? You can decide to do certain things and to source certain materials from certain countries in order to enjoy free trade treatment, or some other products that is available under custom. And so that's why people would do it primarily. With USDA, you could do it that way also. In other words, you would want to be sourcing material that you're going to be using that's animal protein or plant protein that USDA cares about. Then you would be bringing those, the origin would be from countries where there's less restrictions or there's no exclusion. So that would be a regulatory reason to do it, as opposed with customs. It's mostly about the buying.
So Ben, expand on that because you just mentioned CBP towards the end there. What are the consequences if CBP disagrees with the declared origin of the country?
So customs will ordinarily, they could have that question at the border, but that would be because there would be probably evidence of transshipment. If they could see that it was coming through a particular supply chain that they already questioned about, they could set that aside and then detain it and conduct their investigations right away. They don't usually do that unless the life reflection, right? So ordinarily customs will ask the question to the importer after the goods have already cleared, you've already paid or not paying your duty, and you've had your opportunity and you failed to, right? So they sort of give you the opportunity to give it a road and allow you to hang yourself. Then they come back and do the investigation. When they do the investigation, that they determine that that's so wrong, that you can challenge that, or you can pay it. If they're right, customs is right, the duty is going to be due, the interest is going to be due, and there's risk of penalty. That happens after the fact. Here's the important thing. I have clients that are doing this assessment, and they should have done it 5, 6, 7 years ago. Because if you're doing it wrongly, if it turns out your origin is wrong and it's having a detrimental effect on whether you're getting adequate duty payment, right? You're not paying enough because you used the wrong origin for the last 3, 4, 5, 6 years. Customs can go back 7 years and collect the duty that you didn't pay and the interest over the 7 years, and you're going to have to pay all that. And you may have a penalty. You have the option of doing what's called a prior disclosure, but you have to do that before customs is technically investigating you, right? You can't have them start investigating and then do what's prior disclosure. Prior disclosure is what it sounds like. We think we have a problem, customs, right? This is the Houston, we have a problem. This is customs, we have a problem. We think we may have misclassified something, or we think we have a wrong origin on something, and we're investigating it. You can do it a couple different ways, but you want to do that prior disclosure before they start investigating. If you start investigating and say, "Oh, we have a problem," they're going to say, "Yeah, no kidding." Right? I almost swore there, right? Because it's customs. That's what we do. Right. So they'll say, "Yeah, no kidding. You have a problem. We already know that because we started the investigation," and you don't get the benefit of that disclosure. What the benefit? The benefit is you're going to pay the duty. You're probably going to pay the interest, but you won't pay the penalties. And the penalties can be substantial. So it's important to, first, you don't just do a prior disclosure. You've got to get advice, legal advice. You want to make certain first of all, you better be right before you do a prior disclosure. And secondly, if you need to do one, you got to get it done. And you got to get it done in a way that's sort of minimizing that because customs can bring a fraud investigation that they think you did it intentionally. And you don't want that because those penalties are substantially high. And I'm not even talking about criminal investigation. I was a criminal investigator for the FDA for 6 years. And so I investigated criminal violations in Miami and all over with the Southeast. But I'm not even talking about that level of enforcement. If it's a penalty case, but it involves fraud or conscious disregard of the truth, your penalty is going to be substantially higher. You can get up to 3 times the invoice value of the goods on top of the duty that you have to pay and the interest. So it can be extremely expensive.
So it's safe to say devil's in the details, obviously, Ben. So let me ask you, I'm assuming, and you can answer this in terms of common scenarios that you've seen where companies accidentally, maybe they misdeclare the origin and it's been around. What types has it been around? Raw materials, repackaging? Where have you seen these common scenarios where these companies maybe accidentally misdeclare the origin? What should they do when they do?
Yeah. So where it happens is you just described a couple. So what countries are trying to do in those circumstances is they're trying to do something in another country where the duty treatment is lower. That would change the origin to that country. And so they'll bring raw materials into another country, and you've got raw materials coming from country A. They ship them to country B, and they do a manufacturing step in order to combine them, blend and mix them, maybe even process, heat them, cook them, do chemical synthesis, whatever. and then you end up with a finished good that you export to the United States. The question is whether that activity is sufficient to substantially transform the good. The substantial transformation is the test. It's too complicated to get into that VR, but it sort of sounds like what you expect it to be. You've substantially transformed the nature of the goods. And there's a couple of rules for that. Did the tariff shift, right? When you brought it into country A or from A to B, it was tariff code X. But then you did your processing, and then when it left, it was tariff code Y because it's not the same good, right? It's not X sub A or X sub 1, right? Not just another version of X. It's a different thing. And you can successfully make that change in origin. But if you don't accomplish that or things like that, then it's not going to be an actual change of origin, and it gets declared incorrectly in the United States. Packaging almost never is going to cut. Right? You can't just repackage goods and think you could change the origin. It's not going to fly. Even in the pharmaceutical industry, there's been a long battle with respect to whether or not active pharmaceutical ingredients, right? This is the nature of the drug. When you buy an acetaminophen tablet, without giving any brand names, right, at CVS, it's a 500 milligram tablet. That tablet doesn't weigh 500 milligrams. Right? Well, what's the other? The other stuff is not the active ingredient. The acetaminophen is the API, the active ingredient. Everything else is excipient. The API, when it was made in country A, and it went to country B. It was pressed into a tablet with a whole bunch of other stuff. There may be some processing, but it's relatively minimal. The manufacturer had to obtain an FDA approval to sell the drug in the United States, and FDA does what? They approve the label. So FDA approves the label, but FDA's not doing it with origin in mind. They're doing it with their own rules, as to who made the goods, who distributed. Customs had been in a big battle with pharma for years, where Customs' opinion was that the API is the drug, and it doesn't matter when you put it into a capsule. It's still the original API drug. We haven't changed it. So it's the original country of the source of the API. API is the origin, even if you encapsulate it or you tablet it in the United States. It doesn't change it to U.S. origin. So you can see how people can make mistakes, and there was litigation over that. Customs won, and now Big Pharma is trying to figure out how to do all their labeling and change their labels with the Food and Drug Administration because the labels. So it can be very, very complicated, very complex.
Ben, let me ask you, because this is something and kind of a one-off before we get back on the other stuff. There's been like this trend on social media of people claiming that something was made in the USA. You see the rubber stamp on it, and then you find out, like you said, parts were made in other countries, and then it was stamped like this. Is made in the USA still a protected claim? And what does it take to back that up legally?
Yeah. So answer yet. In fact, it's not just the customs that regulates that. The Federal Trade Commission regulates that. Because it's essentially a marketing advertising claim, and so FTC has jurisdiction of the marketing advertising, and labeling is just a special form of advertising. So the answer is there is such a thing. The same basic rules apply. So if you cannot document the same kinds of things we've been talking about, the central nature of the goods originated here in the United States, then you're not going to be able to make that claim. And it's the other thing is if you say Mike, that your company in Miami is if your company's name is on the label of a product, it doesn't say made in the USA or anywhere else, right? That's going to be presumed to be a made in the USA claim, right? Because people are going to look at that, assumes you must be the manufacturer because your name is on it. So not having an origin claim can very often be interpreted to be a made in the USA claim. And it's very heavily protected for the reasons you could just said. A lot of people want to buy made in the USA, and so it has value. Therefore, the FTC regulates that, enforces it, and can take you to court. Those fines are completely separate from CBP.
Save your documentation is what I'm hearing from this. Yeah. So let me ask you, let's put a bow on this. What would be your advice for folks out there, businesses that are importing, whether it be blended, multi-source, repackaged, FDA regulated goods? What's your advice to them?
Well, think about, first of all, do your origin evaluation now and make sure you're making the right declarations. Because if you're not, you're going to have a second thought about whether you need a prior disclosure, because you have to think about the things you already did. You can't undo those. So you've got to figure out what you're doing. Then you want to know what the origin declaration is because you want to determine whether you want to change it. Is there a reason that you would change it? And if you can change it, Maybe you even change the HDF classification when you import the material that's coming in the United States. You might bring something that's excluded from some of these tariffs, even though it's coming from another origin. So you're doing an origin evaluation and an HTS evaluation. That's the tariff code classification that customs use it. But you're going to want to do that, and you want to document all of it. If you didn't document it, you didn't do it. Period. Right. So you have to document all of these things, and then you ought to get some advice and have someone else look at it. And we'd be happy to do that at FDAImports.com. I could get my customs attorneys on it. We do that.
Well, Ben, thanks for the insights and analysis on this. Everybody truly appreciates it.
Thanks, Mike. Great to see you.
And thank you, everybody, for watching this episode of FDA Imports Cross-Border Compliance. When it comes to origin declarations, a small error can have big consequences. You heard what Ben just said. Visit them over at FDAImports.com to get clarity or compliance review before your next shipment. If you like this episode, do me a favor. Be sure to like, subscribe, leave us a review. As always, I'm Mike Leon. Thanks for watching.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.